types of intellectual property. The term intellectual property is usually thought of as comprising four separate legal fields. First, trademarks. Second, copyrights. Third, patents. And fourth, trade secrets. Trademarks and service marks. A trademark or service mark is a word, name, symbol or device used to indicate the source, quality and ownership of a product or service. A trademark is used in the marketing is recognizable sign, design or expression which identify products or service of a particular source from those of others. The trademark owner can be an individual, business organization or any legal entity. A trademark may be located on a package, a label, a voucher or on the product itself. For the sake of corporate identity, trademarks are also being. In addition to words, trademarks can also consist of slogans, design or sounds. Trademark provides guarantee of quality and consistency of the product or service they identify. Companies expend a great deal of time, effort and money in establishing consumer recognition of and confidence in their marks. Trademark protection ensures that the owners of marks have the exclusive right to use them to identify goods or services or to authorize others to use them in return for payment. The period of protection varies, but a trademark can be renewed indefinitely upon payment of the corresponding fees. Trademark protection is legally enforced by courts that in most systems have the authority to stop trademark infringement. Copyrights. Copyright protects literary, musical, dramatic, artistic, architectural, audio and audiovisual works from unauthorized reproduction. Copyright laws grant authors, artists and other creators protection for their literary and artistic creations, generally referred to as works. A closely associated field is related rights or rights related to copyright that encompass rights similar or identical to those of copyright, although sometimes more limited and of shorter duration. The beneficiaries of related rights are performers such as actors and musicians in their performances, producers of phonograms, for example compact discs, in their sound recordings, and broadcasting organizations in their radio and television programs. Copyrights offer the most basic protection for software. This is one of the strongest weapons against software piracy. Copyright laws give owners the ability to prevent others from making copies as well as from creating or selling works that are very similar to the copyrighted work. The weakness of copyright laws is that they do not offer protection to the ideas underlying the program. Ideas and concepts could be used by competitors when they are not protected by patents. Copyright ensures certain minimum safeguards of the rights of authors over their creations, thereby protecting and rewarding creativity. Creativity being the keystone of progress, no civilized society can afford to ignore the basic requirement of encouraging the same. Economic and social development of a society is dependent on creativity. The protection provided by copyright to the efforts of writers, artists, designers, dramatists, musicians, architects and producers of sound recordings, cinematograph, films and computer software creates an atmosphere conducive to creativity, which induces them to create more and motivate others to create. In India, the law relating to copyright is governed by the Copyright Act of 1957, which was amended in 1983, 1984, 1985, 1991, 1992, 1994, 1999 and 2012. to meet the national and international requirements. In 1999, the Copyright Act of 1957 was further amended to give effect to the provisions of the TRIPS Agreement, providing for term of protection to performers' rights at least until the end of a period of 50 years. The Act is now amended in 2012 with the object of making certain changes for clarity, to remove operational difficulties, and also to address certain newer issues that have emerged in the context of digital technologies and the Internet. While discussing the copyright law, it is necessary to understand Creative Commons too. What do you mean by Creative Commons? Creative Commons, or in short CC, license. A Creative Commons CC license is one of several public copyright licenses that enable the free distribution of an otherwise copyrighted work. A CC license is used when an author wants to give people the right to share, use, and build upon a work that they have created. CC provides an author flexibility. For example, they might choose to allow only non-commercial uses of their own work, and protects the people who use or redistribute an author's work from concerns of copyright infringement as long as they abide by the conditions that are specified in the license by which the author distributes the work. CC licensed music is available through several outlets such as SoundCloud and are available for use in video and music remixing. There are several types of CC licenses. The licenses differ by several combinations that condition the terms of distribution.